Hello everyone, this is Nitin Singh, and as it can be seen that we are going to cover important topics for UPSC prelims 2024. Uh, these are most selected topics which could be important for the exam perspective. So we'll begin with election of president, and we'll try to cover it fast so that time can be saved and also the concepts can be well understood. So, the president is said to be the head of state. So he is de jure head of state, not the de facto head of state. De jure head of state, that means his his roles are limited to the stump. His duties are limited to the ceremonial in nature, right? And his position is equivalent to the position of monarch in England. So he's a de jure head of state, not the de facto head of state. De facto head of state is the leader of the biggest party, the leader of the government, which could be the Prime Minister of India. So Prime Minister of India enjoys the status of de facto head of state. So he's also said to be the first citizen of India and symbol of solidarity, unity, and integrity of the nation. Is a part of Union Executive with Vice President, Prime Minister, Council of Ministers, and Attorney General of India. So let's understand what is the procedure for the election of president. So he's not directly elected as the representatives of Lok Sabha. He's represented by a collegium called the Electoral College, which is elected from both the Lok Sabha, Rajya Sabha, and the elected members of State Legislative Assembly. So as we can see here, uh, from the Electoral College responsible, right, from the Lok Sabha, Rajya Sabha, legislative assemblies, and legislative assemblies of Union territories of Delhi and Pondicherry is also included in his election. So let's try to understand uh, what is the value of vote of a MP in his election and an MLA. Value of vote of an MLA. So value of vote of an MP is the total value of the votes of all the MLAs of all states, right? Divided by total number of elected members of parliament, right? You'll get, if you divide the total value of the votes of all the elected members of uh, state legislative assembly participating in president election, if you divide it by the total number of elected members of parliament, you'll get the value of vote of an MP. Similarly, you can get the vote of an MLA by dividing the total population of a state with total number of elected members in the state legislative assembly, and then multiplying it by 1 by 1000, you'll get the value of the vote, right? That's just the little bit of theory, mathematical theory. Okay, so as we can see, the president, uh, like Draupadi Murmu ji, is here. So she's elected by the member of both the houses of parliament and the elected members of legislative assembly of states. So one thing here we are supposed to note that the nominated members do not participate in the election of president, only the elected members, right? So what are the principles which can be used? Uh, so proportional representation by the means of single transferable vote, right? It is a system of voting. If the Supreme Court is involved in president election, we need to see it here. Any dispute related to his election is taken by the Supreme Court, right? So there is any dispute related to the presidential election, it will be taken up by the Supreme Court, and the decision of Supreme Court is final. After the election, a president is declared null and void. Okay, what happens if the decision of president is taken decision for the presidential election is declared null and void? The the acts done by him when he was in office, when he or she was in office, it does not go away, right? It remains in existence. This is what it says, that even after his removal, the acts done by him remains valid. So qualifications, what are the qualifications to become a president? A candidate has to meet some qualifications. Okay, let's see that he should be the citizen of India. His age should be minimum 35-year age, and he should be qualified for the condition to be elected as a member of Lok Sabha, right? So he should also qualify that criteria. He should not hold any office of profit. Office of profit under the central government, state government, or any public authority. So president should also not hold any office of profit. Let's understand important point. Who are not party to the election of president. So the nominated members of Lok Sabha, which are two, and now they don't exist, and Rajya Sabha, which are 12. So they don't participate in the election of president, neither the nominated member of state legislative assembly or legislative councils. And also the members of legislative council, they don't even participate, right? The legislative council, either they are elected or they are nominated, they don't participate in the election of president. Nominated member of Union Territories of Delhi and Pondicherry, they also don't participate. So let's analyze the terms of the president office. Once president is elected, he holds office for 5 years. Yes, but when the Lok Sabha dissolves, right, as it say, he sits in office even after the completion of 5 years. 5 years, given no new election has taken place and no new president has been elected till then, right? Till the time the new president does not get elected, he enjoys being a president. And there is no time limit for the president to get elected and re-elected, right? Like he can be elected and re-elected again and again. So the next topic is minorities in India. And as we know, constitutionally, we have two kinds of minorities, linguistic and religious minorities, which is recognized by the Constitution of India. And specifically, there are some articles dealing with minorities of India and the safeguards provided within the framework of those articles, like the Article 29 and Article 30 of Indian Constitution. So we'll see, as in 2005, there were 5 minority, and later on it became 6. So what were the 5 minorities? So it was Muslims, Christians, Sikhs, Buddhists, and Parsis, and later on 2014 January also added to it. So let's analyze in terms of percentage. Muslims are 14.2%, right? You can see Muslims are 14.2%, and then Christians are 2.3. It is ironical to see that Christian population in India is higher than the Sikh population, which are merely 1.7%. The Buddhist, they are 0.7%. Jain, they are 0.4%. And Parsis, they are 0.006%. Right. So this can be seen through this graph as well, histogram as well. Now, constitutional provision related to the minorities. Article 29, it deals with the protection of interest of minorities, right? And it says that any section of citizen residing in the territory of India or any part thereof having a distinct language, right? A distinct language, script, or a culture. These are 3 different important words: distinct language and language, script, or culture of their own shall have the right to conserve it. So this comes through the Article 29. Then Article 30. What is Article 30 of Indian Constitution? Article 30 relates to the they can these minorities, either they are linguistic or religious, they have the power, they have the right of administering and opening their own educational institution, right? So this is something that it says, right? They can establish and administer educational institution of their choice, right? Okay, so this is something. Then there is another article, Article 350A. This is very important with respect to minority, in which president can appoint a special officer who could look after the rights and the provisions related to safeguards provided to the minorities in the Constitution. The special officer for linguistic minorities, right? Within the, we must understand this is not religious minority, this is not for religious minorities, it is for linguistic minorities. Article 350A. So these terms should be remembered clearly, because if you get a question, don't get confused. It's a religious or linguistic. Okay, so we have National Commission of Minorities, which was its setup started in 1978 and it got enacted in 1992, right? With National Commission for Minority Act, right? And it became a statutory body. Statutory means it is backed by the law of Parliament. That 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 is meant by the statutory. If it is included in the Constitution, it is called constitutional body, right? So the what is the composition of this minority commission? It has a 7 members, which includes a chairperson and a vice chairperson, right? With 5 other members, right? And it is must that all the members should belong to minority community, right? And they must be, obviously they must come from eminent background, and they hold office for 3 years. They hold a office, the members of minority commission hold office for 3 years. Okay, so now we come to another important topic, very important topic, anti-defection law. This has been in news because most of the time, because of the defection of the members from one party to another. Let's understand what is defection. So defection is basically like leaving your party and joining any other party, and what it does, it contravenes the basic principle of governance, basic principle of stability, because if the government doesn't have the support of its member, so it is going to lose confidence in the house. That will tantamount to the dissolution of the house. So this law was much needed to protect the stability of the government of the day. So what is defection? Defection by the legislator occurs in many democracies. It can be argued that they can undermine the stability of the government, which is dependent on the support of the majority power parties, own elected legislators, or a coalition of those elected to represent other parties. The argument follows that such instability can amount to a betrayal of the people's mandate, as vast as the most recent prior election. Almost 50% of the, now this is giving a data why the defection law was introduced in India, because 50% of 4,000 legislators elected to central and federal parliaments in 1967 and 71 general elections subsequently defected, leading to political turmoil in the country, right? This was the background in which the idea of anti-defection law comes into being and formulated in 1985 with 52nd Amendment Act, right? Passed by the Parliament of India. So what is anti-defection law under Indian Constitution? The anti-defection law aims to punish legislative members for changing political parties, right? 52nd Amendment Act, it comes through 52nd Amendment Act 1985 and added the 10th schedule to the Constitution, right? So this is also called anti-defection law, provided that the members will be disqualified for being the member of parliament, right? And it is also valid for state legislature on the ground of defection from one political party to another. So this is not just applicable to this anti-defection law is not just applicable to the parliament, but also applicable to the state legislature, right? Okay, but one thing was allowed, merger was allowed, even like there the party members were defecting from one party to another, but they're moving like 1/3 of the party members are moving from one party to another. It was not called defection, it was called merger. But later on, with 91st Amendment Act 2003, as it can be seen here, uh, this number, this group, which was needed to merge to another group, another political party. Earlier it was 1/3. Now it has become 2/3. So minimum requirement for merger has become 2/3, right? Now minimum 2/3 members are needed to join another party. So what are the major provisions of Anti-Defection Act? Okay, what are the major provisions? Let's see it. So disqualification of members of political parties. Okay, a member of a member of a house belonging to any political party becomes disqualified for being a member of the house if he voluntarily gives up his membership in such a political party, right? So if anybody who's elected on the name of party's ticket and he voluntarily gives his resignation, he becomes disqualified to that particular legislature. Again, one important aspect of stability is not going contrary to the opinion of the party, which is also called whip in political language. So if anyone abstains from voting in contrary to the direction issued by the political party, if you don't go with the party, you don't go with the advice of the party, with the decisions of the party, obviously uh, you can be disqualified as the member of parliament or state legislature, right? So this is also called whip. From the above provision, it is clear that a member elected on a party ticket should continue in the party and obey party's direction. It is very important that you obey party's direction. Independent members are not allowed to join a party, right? They're not allowed to join a party. If they join a party, once they become member of parliament or MLA, so their membership will be declared null and void under anti-defection law. So nominated members like 12 members of Rajya Sabha and the 2 members of Lok Sabha. Nominated members can also not 2 Anglo-Indian members of Lok Sabha. Now I don't think that they exist because their numbers were low, and this provision has been eliminated from constitutional provision. But nominated members, if they join any political party after expiry of 6 months, so they also become disqualified under anti-defection law, right? Within 6 months, right? So a nominated member of the house becomes disqualified from being a member of the house if he joins any political party after the expiry of 6 months. Okay, means he can join any party within 6 months, not after 6 months, right? After 6 months, if they join, their memberships will become null and void. What are the exceptions? What are the exceptions to anti-defection laws? So exception, there are some exceptions to it, right? Like for example, if um, a member who belongs to any particular party, he becomes the leader of house, he becomes the presiding officer of the house. For example, he becomes the speaker of the house. So he is supposed to act impartially, right? He's supposed to act unbiased. So for him, this provision of anti-defection does not apply. So as we can see, if a member is, after being elected as a presiding officer of the house, voluntarily gives up his membership of the party or rejoins it, he can rejoins it. He can rejoin it as well. This exemption has been provided because of the dignity of impartiality, and also, right, if the merger is obviously 2/3, if the merger is 2/3 of the party members, they are joining any other party, then it will be called as merger and not the defection. Who will be the deciding authority in anti-defection cases? So deciding authority in obviously the presiding officer is going to be the deciding officer, right? The act provided this is now initially the act said that decision of the uh, presiding officer is going to be full and final, and it cannot be questioned in the court of law. But in Kyoto Holohan case 1993, right? Kyoto Holohan case 1993, the Supreme Court declared that above provision is unconstitutional and said that the decision of the presiding officer is also subject to judicial review, right? So means judicial review, which is the review by the Supreme Court of India, is allowed in case of anti-defection law. Who has the power to make rules regarding anti-defection law? Rule making power related to obviously the presiding officer of the house is empowered to make rules to give effect to the provisions of 10th schedule, right? All such rules must be placed before the house for 30 days. It must be placed before the house for 30 days, right? According to the rules, the presiding officer can take up a defection case only when he receives a complaint from a member of the house. Means suo motu action on the part of presiding officer is not allowed. He will take the action once anybody from the member of the house complains against any other member. He may also refers, okay, so before making the final decision, he must give the member against whom the complaint has been made a chance to submit his explanation, right? Okay, so what are some new provisions under the amended anti-defection law of 2003? The total number of ministers. Okay, it says the total number of ministers, including the prime minister, should not be less than 15% of total strength of the Lok Sabha, right? And the same goes for the same goes for the state legislative assembly as well, right? Including the chief minister. The members should not be less 15%, right? Okay. And but it must be noted that in case of state legislative assembly, the members of council of minister, including chief minister, should not be less than 12. They should not be less than 12 in any case, right? So any member of either house of state legislature belonging to any political party who is disqualified on ground of defection shall also be disqualified to be appointed as minister, right? Okay. So means he can also not hold, if he is disqualified under anti-defection law, he can also not hold any remunerative political post, right? Okay, now comes to our next important topic, that is delimitation of Kashmir. Okay, we must be aware what does it mean by the delimitation. Delimitation means that adjusting the constituency by delimitation commission, because there has been changes in the population of that constituency. This is a simple meaning of delimitation. Delimitation commissions have been put into place for different occasions. For example, for the current time, the delimitation commission of 2002 act is in place, right, which will decide the delimitation of the constituency of a state based on delimitation act of 2002, right? So we can see 4 times delimitation. And also for 2002 delimitation act, right, the census used is 2001 in case of Jammu and Kashmir, right? Otherwise, for other states, the census used is of 1971. So this is why this delimitation of Jammu and Kashmir has been completely questioned by the politicians of the state of Jammu and Kashmir. Now, it was constituted in 1952, then 1963 under different delimitation acts, and then 1973, and now current delimitation act of 2002, right? Also, it is given in Article 82 of Indian Constitution, right? The Parliament by law enacts a delimitation act for every census, right? And the meaning of delimitation I already told, that it literally means the act, a process of fixing limits or boundaries of territorial constituency in a country or a province having a legislative body, right? Okay, so we have this. The Delimitation Commission demarcates the boundaries of parliamentary constituency as per as 2002 Act, right? And census use is 2001, right? The present constituency carved out on the basis of 2001 census shall continue to be in operation till first section, first census of 2026, right? Now, okay, let's understand uh, uh, what is the position of after the delimitation of Jammu and Kashmir. Okay, so delimitation Commission of India was awarded this task of delimiting the constituency of newly formed union territories of Kashmir, Jammu and Kashmir, right? So it was given this task, and they have submitted its report, and it was accepted. Rather, this delimitation commission decision is mandatory; it is must, right? But it was questioned in court of law in Supreme Court, and Supreme Court rejected the petition filed against the decision of delimitation act. Now, delimitation commission. So delimitation commission has allocated 40, like it was the earlier decision, like there was 46 seats in Kashmir and 37 in Jammu and 4 in Ladakh and 24 seats in POK. Now it has changed. Now earlier the Jammu had 37 seats of legislative member MLAs in Jammu. Now it has raised from 37 to 43. And one seat has been raised in case of Kashmir, right? And also they have raised some in POK. Now we must understand a parliamentary constituency has been carved out of parliamentary constituency has been carved out. Parliamentary constituency means the constituency for the election of Lok Sabha, right? And it has been carved out from both the UTs, Kashmir and Jammu, right? And by combining the Anantnag part of Kashmir and Rajouri and Poonch part of the Jammu, right? So this was challenged in the court of law, and it was denied by the Supreme Court that the decision of delimitation commission, and it was challenged on the ground that the census used for the delimitation of UTs of Jammu and Kashmir is 2001, but for other states it was used 1971 census. So they have violated, but uh, the Supreme Court of India has denied this argument, and the delimitation was proved. Okay, now can the order of the delimitation commission be questioned in court? The delimitation commission of India is a high power body whose orders have the force of law, cannot be called in question before any court. The orders come into force on a date to be specified by, but this was questioned, right? This text must be taken from some static book. I don't know, because I didn't see this while making the PPT, but now you need to understand this was questioned. The decision of the delimitation commission was questioned, and the court has adjudicated against the petition filed. Whether any modification is possible in order of delimitation commission. Okay, the copies of its order are okay. The copies of order are laid before the House of the People and the state legislative concerned. Okay, means the copies are placed before the legislative Lok Sabha and the state legislative assembly which is concerned, but modification is not permissible. This cannot be modification, right? Okay, so we are going fast. EWS quota. Let's try to do it faster. What is EWS quota? Obviously, we understand it is the 10% reservation, extra reservation given to the general caste, because we already have reservation in educational institution and government jobs for ST, SC, and OBC community. But there was no reservation for allocated for the economically weaker section of unreserved category of general category. So this 10% extra reservation was allocated for this particular section. So we can see, right, it was introduced, 10% EWS quota was introduced under 103 Constitutional Amendment Act 2019. We must understand this. And it was introduced by amending two articles, Article 15 and Article 16. And specifically, it inserted Article 15 Clause 6 and Article 16 Clause 6, right? And it is for the economic reservation in jobs and admission in educational institute of economically weaker section, right? As it is said. And this all is the same thing. You can read. Okay, what is doctrine of adverse position, Davising case? This is very important. And doctrine of adverse position means that, okay, if you are living on a land, on a patch of land for more than 12 years, and the owner of the land and a property does not like, he does not contest it in the court of law, that means you can apply for its ownership. This is what we call as a doctrine of adverse position. Okay. Now let us understand what is Justice Rohini Commission. This is a very important topic. Justice Rohini Commission to examine subcategorization of other backward classes. Okay, after this subcategorization of other backward classes, it was contemplated in 2017, and this commission was formed in 2017 to subcategorize the OBC, and it had given some recommendation, like it has categorized the OBCs into two parts: 10% with highest benefits, 10% with partial benefits, and 10% of OBCs with no benefits, right? This subcategorization of OBCs has already been implemented by as many states as 11 states, and it is highly implemented in state of Bihar, right? So let us try to understand and what is development. But this subcategorization has not been implemented pan-India basis. The critics say that BJP does not want to annoy the existing OBC class, OBC caste, because of the subcategorization, because it will take away the benefits given to them. So this was tasked with subcategorization of the other backward classes, right? And commission sent, it already has presented its report, right? It already had presented its report, and it was commissioned in 2017 under Article 340 of the Constitution. Okay, very right. These articles we must read, we must understand. In 2015, National Commission of Backward Classes recommended that OBC should categorize into extremely backward classes, more backward classes, and backward classes, right? This is how, 10% partial benefit, 10% no benefit, and 10% high benefit, the Justice Rohini Commission has categorized. It has submitted its report. So NCBC has the authority, National Commission for Backward Classes has the authority to examine complaints and welfare measures regarding socially and educationally backward classes, right? So with OBCs, they are not defined in, as the backward classes in terms of economics, but these are those classes which are educationally and socially backward, right? So how the OBC reservation has evolved till now, let's understand. Kelkar Commission 1953, it was the first to identify backward classes apart from ST, scheduled tribes and scheduled caste at the national level. Then Mandal Commission report 1980, it asked for 27% reservation for other backward classes, and it classified the out of total population, 52% of the population constitutes other backward classes, right? And there are 1257 communities are backward, right? It recommended increasing the existing quotas, right? And leading it to, at that time the quota was 22.5%, and leading it to approximately 50%, which is also a limit put by Supreme Court in 1991 Mandal Commission case, right? So now the central government has reserved 27% of seats in union civil post and services for union government, right? 27% seats are booked for other backward classes as far as the Article 16 Clause 4, right? And same goes for 15 Clause 4, where same kind of reservation were put in central government educational institution, right? In 2008, there has been many cases, and the court has declared that creamy layer in OBC creamy layer should be based on income property, should be excluded from the ambit of OBCs, right? They should be excluded and they should not be given the benefit of reservation. Okay, 102 Constitutional Amendment Act of 2018, very important, because it has made NCBC from a statutory body to a constitutional body. Now NCBC has become a constitutional body. Okay, the new topic is next topic is a 9th schedule. Let us understand what is 9th schedule. Okay, 9th schedule, apart from the 8 earlier schedules, there was new schedule inserted, which is called the 9th schedule. And 9th schedule was inserted, like it said that the schedule contains a list of central and state laws which cannot be changed in court, and was aided by the First Amendment Act. It was aided in 1951 with the First Amendment Act, and it included those laws, because we must understand the background in brief, that 1950 was the time when the agricultural reform laws were getting implemented. Those were the socialist reform, right? And the fundamental rights of individuals, specifically the right to property, was a limitation to those laws. So those laws could be easily challenged in court of law. So Parliament comes up with new vision, with new initiatives in form of 9th schedule, where putting those laws into the ambit of 9th schedule will make them inviolable. Means those laws could not be challenged in court of law, especially in Supreme Court, based on the violation of fundamental rights, specifically the right to property, right? Because at that time, right to property was a fundamental right. So we must understand this. Okay, these things you can read it by yourself. I'll cover the specific points. So there are different cases related to the 9th schedule and the sanctity of laws put under the 9th schedule, and where judiciary can intervene and where judiciary cannot intervene. So it goes with Keshavananda Bharti case, and after Keshavananda Bharti case, right, it says it was the date 24th April 1973, right? The court upheld the basic structure doctrine, right? And it says that, okay, any part of the constitution can be amended, but it has introduced the idea of basic structure doctrine. That means if it is violative of basic structure of the constitution, the court has the right to review the law, right? And Vaman Rao case 1981, the court has decided that, okay, all the laws which are put after 24th April 1973, that means after Kesavananda Bharati case, those laws can be scrutinized by the Supreme Court of India. This is what it's said in Vaman Rao case, right? And then Coelho case versus State of Tamil Nadu, that it was held that every law must be tested under Articles 14, 19, and 21 if it came into force after. Right. Now it has introduced another layer of protection for the violation of fundamental rights, in form of, if those laws which is coming into force and getting put into Schedule 9, right, they must conform to Article 14, sanctity of Article 14, 19, and 21. Right. So these are something, and the rest you can read it by yourself. So deputy speaker is very important. You can read it by yourself, but I'll just brief you that post of deputy speaker has been vacant in parliament uh, for long, and this has been questioned by the opposition party because since 2011 the tradition has been that post of deputy speaker will be occupied by a member associated with the opposition party of India. As the speaker, usually he belongs to the elected party, means party in power. So, as the deputy speaker, he must belong to party which is a position in the house, right? But the this NDA government has not elected any deputy speaker. So the sanctity of deputy speaker has been means the sanctity of this parliamentary procedure has been questioned, and uh, uh, it it has several problems as well uh, because the court cannot question the proceedings of the parliament. One, that court cannot question the proceedings of parliament. The second, that the government says it already has uh, a committee which could perform committee and the chairpersons of the committee who could perform the functions of deputy speaker, right? So let us understand some of the basics and then just shift to another topic. So Article 19, right? It says as the House of People, uh, okay, says that the House of the People shall, as soon as the choose two members of the speaker and deputy speaker, so often as offices become vacant. However, it does not provide a specific time frame. Okay, so Article 93 it ensures that as the speaker is chosen, deputy speaker should also be chosen, but it does not provide any time frame, right? And Article 178 is the counterpart of the same for the state legislative assembly. So this word shall means people say that it has, since Article 93 includes the shall, it means the appointment of deputy speaker is mandatory, right? And as I said, what union government says that there is a panel of 9 members selected from different parties who can act as a chairperson to assist the speaker to run the house, right? So this is the union government argument why they have not chosen or elected any deputy speaker. Can the court interfere in this matter? Article 122 says, okay, as I said, that court cannot, the validity of any proceeding in the parliament cannot be, because this is one of the basic idea of separation of power, in which any proceeding under the parliament cannot be questioned in court of law. The same way, uh, the the judges, conduct of the judges and their decision cannot be discussed in parliament, right? This is one of the ideals of separation of power. However, experts argue that the courts do have jurisdiction to at least inquire into why there has been no election to the post of deputy speaker, right? Since the constitution does envisage as soon as maybe. Okay. So these are the things I leave it to you to study, right? The constitutional position of the speaker, right? The constitutional position of the speaker is very strong. It is as strong as the speaker because both of them exchange their resignation to each other. They give their resignation to each other. That means constitutionally, he is not lesser to the post of speaker. He performs all the duties and acts what is expected to be performed by speaker, right? So his post is not lesser in terms of stature than speaker, right? And they give their resignation to each other. Now, doctrine of essential practices, hijab issue, like this is a very normal topic because an incident happened in Karnataka where the girls from Muslims, Islamic girls, they were trying, they were entering into the schools and colleges wearing hijabs, and because there were state government regulation, that the religious uniforms are not allowed in educational premises, right? And they must conform to the decorums and the disciplines of the uniform disciplines of the a particular educational institution, right? So based on this premise, actions were taken against these girls and they were not allowed entering into the educational premises wearing hijab. Now they question same thing into the High Court, Karnataka High Court, and Karnataka High Court has decided, has adjudicated that wearing hijab is a part of, it can be the part of choice, but it it is not the essential practice of Islam. It is not essential practice of Islam, right? That means it is not the execution of freedom of religion. You can claim it as a right to privacy or freedom of choice, but not, you cannot claim it the freedom of religion, because it does not constitute the essential part of Islam. Wearing hijab doesn't constitute essential part of Islam, right? And choices and privacy, it also contravene that you cannot claim choices and privacy, because a classroom is a public space, and like a classroom is a public space, and in public space you cannot you cannot the discipline and decorum is given more weightage than your freedom of choices and right to privacy, right? So these are something, and there are some cases related to it. Sirur Mutt case of 1954, where the religion was deciphered, right? Supreme Court case. It was a Supreme Court case, right? And it was to determine what constitute the essential religious practices. So it says the integral part, right? What is integral of a religion is the essential religious practices, right? Okay. And also, there was another case of 1986, and this case says Emmanuel Bizo Emmanuel versus State of Kerala 1986 case, in which these people from Jehovah cult, right? Uh, they they said that this basic national anthem violates their belief of their religion. So they were allowed not to sing and remain silent during the anthem chanting.